exam. 1.1 1.1.1 What law to apply professional responsibility essay questions on the California bar exam can test on the ABA model rules of professional conduct, the ABA rules, the California rules of professional conduct, the California rules, relevant sections of the California Business and Professions Code, and leading federal and California case law on the subject of professional responsibility. Most often, the essay question will instruct you to answer according to California and ABA authorities, meaning they want you to address both. Note, the California bar exam does not test on the Code of Judicial Conduct. ABA versus California. You may remember the ABA rules if you've taken the MPRE and/or a professional responsibility class in law school. In real life, the ABA rules guide the states, but are non-binding and have no effect. In 2018, California became the final state to model its rules of professional conduct on the ABA rules. The new California rules follow the basic structure of the ABA rules, but continue to differ in certain areas. Other California ethics standards are drawn from the California Business and Professions Code, state case law, and state ethics opinions. The ABA rules and California ethics standards often overlap. This outline will usually lead with the ABA rule and then point out any important California differences, if applicable. Professional responsibility, California. Notes. 2. 1.1.2 formats. Professional responsibility may appear on the California bar exam in essays and/or performance tests. Professional responsibility essays are often freestanding, but can also be in crossover format, meaning tested in conjunction with another subject. CMR exam tip. Don't chase phantom professional responsibility questions. The call of the question will usually make it clear when they want you to discuss this subject. 1.2 Misconduct and discipline. 1.2.1 Grounds for discipline on professional responsibility essays on the bar exam. You'll be tasked with looking for ethical violations by lawyers. In other words, you'll need to determine whether the lawyers in the fact pattern committed misconduct that would subject them to disciplinary action. So, it's a good idea to walk through what misconduct means under the rules of professional conduct. The rules tell us that a lawyer is subject to discipline for any of the following actions. Actual or attempted rule violation. You'll be learning about the rules of professional conduct in this outline. It should come as no surprise that a lawyer is subject to discipline for violating a rule of professional conduct or attempting to do so either individually or through the acts of another. B. Crimes and dishonesty. A lawyer is subject to discipline for the following actions, regardless of whether they relate to the lawyer's practice. Committing a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Engaging in any conduct involving dishonesty, fraud, deceit, or misrepresentation. Professional responsibility, California. Notes. 3. CMR exam tip. If a lawyer in an essay fact pattern has acted dishonestly, it's worth briefly mentioning this general prohibition in your answer even when the lawyer has also violated more specific rules. Also note that a lawyer may be subject to discipline under this rule even if they were acting in a personal capacity. For example, a lawyer who commits plagiarism or cheats on a bar examination could be subject to discipline even if it has nothing to do with their law practice. C. Actions that harm the justice system. A lawyer is subject to discipline for engaging in conduct prejudicial to the administration of justice. Knowingly assisting a judge in violating the rules of judicial conduct or other law. Stating or implying an ability to improperly influence a government agency or official to achieve results by illegal or unethical means. For example, you should hire me because my dad is the mayor and I have a lot of connect-ins in this town. A related way to injure the integrity of the profession is for a lawyer to make a statement they know to be false. or make a statement with reckless disregard as to truth or falsity about the qualifications or integrity of a judge, public legal officer, or candidate for these offices. California difference. On this last point, the California rule applies to false or reckless statements about judicial officials and candidates only. It doesn't apply to statements about public legal officers or candidates for legal office. D. Discrimination and harassment related to law practice. A lawyer is subject to discipline for engaging in harassment or discrimination in conduct related to the practice of law. Professional responsibility, California. Notes. 4. Based on a protected characteristic. However, this rule does not affect a lawyer's ability to reject a case or engage in legitimate advocacy. California differences. The California rule concerning discrimination and harassment differs as follows. It only applies to unlawful discrimination and harassment, meaning actions that violate anti-discrimination laws, and also prohibits unlawful retaliation. It also prohibits a lawyer from permitting unlawful discrimination or harassment in relation to a law firm's operations. It provides that a lawyer who is the subject of a disciplinary proceeding alleging a violation of this rule must promptly notify the state bar of any criminal, civil, or administrative action premised on the same conduct. 1.2.2 Disciplinary authority and choice of law. A lawyer is subject to regulation in each state in which they offer legal services or are admitted to practice, meaning a lawyer can be disciplined by multiple states for the same conduct. The choice of law will depend on the circumstances. If the lawyer's conduct concerns a matter pending before a court, the rules of the state in which the court sits will generally apply. Otherwise, the disciplinary authority will apply the rules of the jurisdiction in which the predominant effect of the conduct took place. However, the lawyer will not be subject to discipline if their conduct conformed to the rules of a state in which the lawyer reasonably believed the predominant effect would occur. 1.3 Essay approach. Memorize checklists of the major duties owed to clients and duties to all other entities, like the court and adversaries. Use a building block sentence. The lawyer has a duty of blank to create an essay heading for each discussion of a duty. Professional responsibility, California. Notes. 5. The bulk of duties are those owed to your clients. These are CLFC and other reasonable things. Clients. Do each separately. Duties to entities other than your clients. Mix and match, CFD, and other reasonable things. Court adversaries, parties and their counsel, legal profession, third parties, public. CMR exam tip. There are many ways to organize a full professional responsibility essay. Try FIRAC by identifying all ethically questionable fact triggers. Then, within the call of the question, use the checklist to identify every major duty that you have to each individual client. Next, under each of these client duties, list any conflicting duties to other clients or entities. This is one way to organize your issue outline. Now flesh out these clusters by stating each relevant rule, applying it by analyzing the relevant facts, and drawing a conclusion. Finally, review the problem for any miscellaneous duties, for example, to the public or profession, that you haven't discussed yet. Professional responsibility, California. Notes. 6. 2. Formation, termination, and scope of a lawyer. Client relationship and basic duties to clients. 2.1 Formation of relationship. A lawyer-client relationship generally arises in any of the following three situations. Express agreement of the parties. Implied agreement, based on the intent and conduct of the parties. Usually, this happens when a person seeks legal services and the lawyer fails to clearly decline despite knowing that the person is reasonably relying on them to provide the services. A court's appointment of a lawyer to represent a client. Lawyers are generally free to refuse service to any person for any reason, and must decline to represent a client if the representation would result in a violation of the law or an ethics rule. See 2.2.1, Infra. 2.1.1 Pro bono work and refusing court appointments. Pro bono work is encouraged, but not required under the rules of professional conduct, meaning, a lawyer who fails to perform the suggested 50 hours per year will not be subject to discipline. However, a lawyer must not seek to avoid appointment by a tribunal to represent a person except for good cause, such as 1. Representing the client is likely to result in a violation of the rules of professional conduct or other law, for example, when the lawyer has a conflict of interest. 2. Representing the client is likely to result in an unreasonable financial burden on the lawyer. Or 3. The client or the cause is so repugnant to the lawyer as to be likely to impair the professional responsibility, California. Notes. 7. Lawyer-client relationship, or the lawyer's ability to represent the client. California difference. California did not adopt a rule concerning court appointments. However, in taking the California attorney's oath, each lawyer promises never to reject, for personal or liaisons, the cause of the defenseless or the oppressed. 2.2 Declining or terminating representation. 2.2.1 Mandatory rejection or withdrawal. A lawyer must decline to take on a representation, or must withdraw from representation, in any of the following circumstances. The representation will result in a violation of the rules of professional conduct or other law, for example, there is a conflict of interest or a competence problem. The lawyer's physical or mental condition substantially impairs the lawyer's ability to represent the client. The lawyer is discharged by the client. California difference. The California rule adds another mandatory ground. The client is bringing an action, conducting a defense, asserting a position in litigation, or taking an appeal, without probable cause and for the purpose of harassing or maliciously injuring any person. 2.2.2 Permissive withdrawal. A lawyer is permitted to withdraw if it can be accomplished without material adverse effect on the client's interests, or where there is good cause to do so. Examples of good cause include professional responsibility, California. Notes. 8. The client persists in a criminal or fraudulent course of action involving the lawyer's services. The client has already used the lawyer's services to perpetrate a crime or fraud. The client fails substantially to fulfill an obligation to the lawyer, for example, paying bills, and has been given reasonable warning that the lawyer will withdraw if the obligation isn't fulfilled. The representation has been rendered unreasonably difficult by the client. The client insists on taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. The representation will result in an unreasonable financial burden on the lawyer. California differences. There are various minor differences in the California rule for permissive withdrawal, but the substantive differences are as follows. It doesn't include the ground allowing withdrawal where it can be accomplished without material adverse effect to the client's interests. Rather, withdrawal is allowed if the client knowingly and freely assents to termination of representation. It doesn't include the client insists on taking repugnant action or unreasonable financial burden on lawyer grounds. It lists a few other examples of good cause, all of which would also be considered good cause under the ABA rules. For example, the lawyer is unable to work with co-counsel and withdrawing would serve the client's interests, or the lawyer's mental or physical condition makes it difficult to continue but is not severe enough to require mandatory withdrawal. Professional responsibility, California. Notes. 9. 2.2.3 Must continue representation on court order when ordered to do so by a tribunal. A lawyer must continue representation even if there is good cause for terminating the representation. 2.2.4 Protecting clients' interests on termination. When terminating the representation, a lawyer must take steps to the extent reasonably practicable to protect a client's interests, such as giving reasonable notice to the client, allowing time for employment of other counsel, surrendering papers and property to which the client is entitled, and refunding any unearned advance payments. Scenario: you are a year into defending a breach of contract claim when your client decides he wants his sister-in-law to take over. You have taken depositions, gotten an expert report, and have just drafted a motion for summary judgment on one of the counts. Your client is several months behind on paying your bills. Can you keep the file until you are paid? 2.3 Sale of a law practice. The sale of a law practice or a field of law practice, including goodwill, is permitted subject to the following requirements. The entire practice, or the entire field of practice, must be sold to one or more lawyers or firms. The seller must cease to engage in the private practice of law either entirely or in the sold field of practice, in the geographic area or jurisdiction where the practice has been conducted, but may work as in-house counsel or for a charitable organization. Written notice must be given to the seller's clients regarding the sale, the client's right to retain other counsel and to take possession of their files, and the fact that consent to the transfer of the client's files will be presumed if a client takes no action within 90 days of receipt of the notice. Professional responsibility, California. Notes. 10. Client's fees must not be increased solely because of the sale. The purchaser must honor existing fee agreements made by the seller, but can modify the agreements if circumstances change. California differences. The California rule differs in various ways. All or substantially all of the practice must be sold. A lawyer cannot sell just a field of their law practice in California. It specifically provides that a client's confidential information must not be disclosed to a non-lawyer in connection with the sale. The seller, or the purchaser, if the seller is deceased or disabled, generally must obtain each client's written consent before the client's matter is transferred. However, if reasonable efforts have been made to locate the client and there is no response within 90 days, the client's consent is presumed. The seller is not prohibited from practicing law following the sale. However, the seller and purchaser may choose to include this as a term in the sale agreement. 2.4 Scope and allocation of authority. 2.4.1 When client has final decision, a lawyer must abide by the client's decisions, after consulting with the client, as to the following: whether to accept a settlement offer, what plea to enter, whether to waive a jury trial in a criminal case, whether the client will testify in a criminal case. Professional responsibility, California. Notes. 11. 2.4.2 Assisting client in criminal or fraudulent conduct. A lawyer must not counsel or assist the client in illegal or fraudulent conduct. The lawyer may, however, advise the client of the legal consequences of a proposed course of action. If the client insists on pursuing an illegal or unethical course of conduct, the lawyer must withdraw. California note. The California rule also prohibits a lawyer from assisting a client in conduct that violates a court rule or ruling. The commentary also provides that if California law conflicts with federal or tribal law, for example, with respect to marijuana laws, the lawyer must inform the client about the related federal or tribal law and policy. 2.4.3 Limiting scope of representation. A lawyer may limit the scope of the representation. For example, the lawyer and client may agree that the lawyer will handle only certain aspects of the matter if 1. The limitation is reasonable under the circumstances, and 2. The client gives informed consent. What wouldn't be reasonable? Suppose a client wants the lawyer to research an issue but only wants to pay for 1 hour of the lawyer's time, telling the lawyer, just do whatever you can in 1 hour. If the lawyer knows that they would be unable to provide the client with a helpful answer after just 1 hour of work, it would not be reasonable to limit the scope. 2.5 Special types of clients. 2.5.1 Representing organizations. A. Explaining identity of client. The lawyer represents and owes a duty to the organization, not to the people associated with the organization. The lawyer must explain this whenever the organization's interests are adverse to those of the person at the organization with whom the lawyer is dealing. Professional responsibility, California. Notes. 12. CMR exam tip. To avoid misunderstandings, it's important for a lawyer to clearly identify who their client is. B. Protecting organization's interests. If the lawyer learns that a person associated with the organization has acted, or is about to act, in a Additionally, at the end of the case, the lawyer Additionally, at the end of the case, the lawyer must give the client a written statement showing the outcome, the remittance to the client, and how the remittance was calculated. California difference. California requires 2 additional disclosures. The agreement must state that the lawyer's percentage is not set by law and can be negotiated between the lawyer and client. How the client will be charged for work not covered by the contingency. Failure to comply with the disclosure agreements renders the agreement voidable at the option of the client, and the lawyer will then only be entitled to collect a reasonable fee for services rendered. C. Discharge of lawyer on contingency. A client is free to discharge a lawyer hired on a contingency basis at any stage of the proceedings. Usually, the discharged lawyer will be entitled to the reasonable value of their services performed up to the time of the discharge. However, the lawyer's claim does not arise until the contingency comes to pass. In other words, the lawyer isn't entitled to get paid unless and until the client recovers. Hypo 6b. After a year of work, Bud fires his lawyer Vinny before the case is tried or settled. If they had a contingent fee agreement, can Vinny recover any fees? Note, if a lawyer was discharged because of an egregious ethical violation, the court may determine that the lawyer forfeited their fee. Professional responsibility, California. Notes. 52. D. When contingent fees are prohibited, a lawyer must not enter into a contingent fee agreement in either of the following circumstances. Defending a client in a criminal case. Representing a client in a domestic relations case where the fee is contingent on the securing of a divorce, the amount of an alimony or child support award, or the amount of a property settlement. However, a lawyer may use a contingent fee in a suit to recover post-judgment balances due under an existing order. 6.4 Handling money and property. 6.4.1 Separation of funds. Money that a lawyer receives in connection with a representation, whether from the client or a third person, must promptly be placed in an interest-bearing client trust account, separate from the lawyer's own personal and business accounts. The lawyer must never place their own money or their firm's money into the client trust account, except for the sole purpose of paying bank service charges. The interest after bank service charges goes to the client. If the client's funds are too small in amount or held too briefly to earn interest for the client, the lawyer must place the client's funds into a pooled client trust account, known as an IOLTA account. The interest goes to the state bar to fund nonprofit legal service organizations. California difference. The California rules relating to trust accounts more specifically apply to all funds received or held by a lawyer for the benefit of a client, or for the benefit of a third person to whom the lawyer owes a legal duty. For example, a lawyer holds a duty to a third person when the third person, for example, a medical provider or the client's former attorney in the case, holds a valid lien over the client's recovery, or professional responsibility, California. Notes. 53. The lawyer agrees to act as escrow holder for a transaction between a client and the third person. The trust account must be maintained in California, or, with the client's written consent, in a different jurisdiction with which the client has a substantial relationship. Placement of advance payments. An advance payment from a client must be put into the client trust account, to be withdrawn by the lawyer only as fees are earned or expenses incurred. This is because an advance payment belongs to the client until it is earned by the lawyer. As we have discussed, the lawyer must refund to the client any unearned advance payments at the end of the representation. California difference. The general rule for advance payments is the same in California, but the California rule also provides that a flat fee may be deposited into the firm's operating account, provided that the lawyer discloses to the client in writing that the client, 1. Has a right to require that the flat fee be deposited in a client trust account until it is earned, and 2. Is entitled to a refund of any unearned amount if the representation is terminated or the services are not rendered. Additionally, if the flat fee exceeds $1,000, the client's agreement and the disclosures above must be set forth in a writing signed by the client. 6.4.2 Safekeeping and delivery of property. A lawyer must identify and label securities and properties of the client or third person and put them in a safe deposit box or author place of safekeeping as soon as practicable. Promptly notify the client or third person when the lawyer receives funds or property in which the client or third person has an interest. Professional responsibility, California. Notes. 54. Promptly deliver funds or property to which the client or third person is entitled. Keep records for at least 5 years after final distribution of the property, and render written accountings. 6.5 Disputed funds. Recall that a lawyer may owe a legal duty to third persons who are not the client, for example, when the lawyer is acting as escrow agent or when a third person holds a lien on the client's property. When a lawyer possesses property in which at least 2 persons, one of whom may be the lawyer, claim interests, the disputed portion must be kept separate by the lawyer until resolution of the dispute. However, the lawyer must promptly distribute all portions of the property that are not in dispute. This means that if the client disputes the lawyer's fee, or if there is a dispute between the client and a third person who has a legitimate interest in the funds, the lawyer must keep the disputed portion in the client trust account and seek prompt resolution of the dispute. 6.5.1 Procedure for resolving fee disputes. A lawyer must comply with any mandatory procedure for resolving fee disputes, for example, an arbitration or media tie-in procedure established by the state bar. California note. In California, the lawyer and client may agree in advance to arbitrate fee disputes. If they have not agreed in advance, the client may force the lawyer to arbitrate, but the lawyer may not force the client to do so. Hypo 6C. A lawyer working under a 1/3 contingency agreement receives a $30,000 settlement check. He deposits it into the client trust account and informs the client and encloses a bill for $10,000. The client calls and says, "I think you've." Professional responsibility, California. Notes. 55. Only done $5,000 worth of work. What should the lawyer do with the money? 6.6 Splitting legal fees. 6.6.1 With other lawyers in firm partners and associates within a law firm can generally pool and split legal fees however they'd like. Additionally, a law firm can make payments to a former partner or associate under a separation or retirement agreement. 6.6.2 With outside lawyers, a lawyer may share legal fees with a lawyer at a different firm if the total fee is reasonable. Either A. The split is in proportion to the services performed by each lawyer, or B. The split is in some other proportion if each lawyer assumes joint responsibility for the matter, and the client agrees to the split in a writing that discloses the share each lawyer will receive. California difference. The California rule allows true referral fees. It does not require that the split be proportionate to services or that the lawyers assume joint responsibility for the matter. Although the referring lawyer need not be involved in the matter, the following is still required. The agreement between the lawyers to divide the fees must be in writing. The total fee charged by all lawyers must not be increased solely by reason of the agreement to divide fees. The client must provide written consent to the division and its terms. Professional responsibility, California. Notes. 56. Hypo 6D. Jacob gets a great personal injury case, but it's based in LA, which he regards as a gridlocked armpit. He refers the case to Meyer, who does all the work and wins $1 million. Can Meyer share the fee with Jacob as thanks for the referral? 6.6.3 With non-lawyers, a lawyer or law firm must not share legal fees with a non-lawyer, subject to the following limited exceptions. Paying a death benefit to a dead lawyer's estate or other designated persons. Purchasing a law practice of a dead, disabled, or disappeared lawyer and paying the purchase price to the estate or non-lawyer representatives. Including non-lawyer employees in a compensation or retirement plan, even if the plan is funded by legal fees. Sharing court-awarded legal fees with a non-profit organization that employed or recommended the lawyer in the matter. California difference. The California rule recognizes 2 additional permitted grounds for sharing fees with non-lawyers. Sharing non-court-awarded legal fee with non-profit organization. As discussed above, a lawyer may share a court-awarded legal fee with the non-profit organization that brought the lawyer into the matter. In California, if a legal fee is not court-awarded but arises from settlement or other resolution of the matter, the lawyer may still share the fee with the non-profit organization that brought the lawyer into the matter if the following conditions are met. The organization qualifies as exempt from federal income tax under Section 501 SC 3 of the Internal Revenue Code. Professional responsibility, California. Notes. 57. The lawyer enters into a written agreement with the organization to divide the fee. At the time of the agreement with the organization or as soon thereafter as reasonably practicable, the lawyer provides the client with written disclosure of the proposed fee division and its terms, including the identity of the organization, and obtains written consent from the client, and the total fee charged by the lawyer is not increased solely by reason of the agreement to divide fees with the organization. Payments to lawyer referral services. A lawyer or law firm may pay a prescribed registration, referral, or other fee to a lawyer referral service established, sponsored, and operated in accordance with the State Bar of California's minimum standards for lawyer referral services. Professional responsibility, California. Notes. 58. 7 duties to courts. 7.1 Candor to the tribunal. A lawyer is required to present the law, facts, and evidence to the tribunal in a truthful manner. For purposes of these rules, a tribunal means a court, an arbitrator in a binding arbitration proceeding, or a legislative body or administrative agency acting in an adjudicative capacity, that is, making a binding legal judgment after hearing evidence. 7.1.1 Stating the law and facts. A lawyer must not knowingly make a false statement of fact or law to the tribunal. Additionally, the lawyer has the following affirmative duties. A. Correcting false statements. If the lawyer previously made a false statement of material fact or law, the lawyer must correct their statement. B. Disclosing facts in ex parte proceedings. As a general rule, a lawyer is under no obligation to volunteer a fact that is harmful to their client's case. However, in an ex parte proceeding, meaning where the other side is not present, the lawyer must inform the tribunal of all material facts known to the lawyer that will help the tribunal make an informed decision. C. Disclosing harmful legal authority. A lawyer must not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction that is directly adverse to the client's position and that has not been disclosed by opposing counsel. California note. The California rule also specifically prohibits a lawyer from knowingly misquoting to a tribunal the language of a book, statute, decision, or other authority. Professional responsibility, California. Notes. 59. 7.1.2 False evidence. In general, the general rules with respect to false evidence, whether testimony or physical evidence, are as follows. Note that special rules apply to false testimony by a criminal defendant client and are discussed in 7.1.3 below. A. Knowledge of falsity must not offer in a matter pending before a tribunal. The lawyer must refuse to offer evidence that they know is false. Hypo 7a. You represent bombing defendant Ted at trial. The morning that Ted's brother is to testify, you discover that he plans to lie and claim that Ted was with him across the country on the day of the crime. If he refuses your advice to testify truthfully, what do? B. Reasonable belief in falsity usually may refuse to offer if a lawyer doesn't know, but reasonably believes that testimony or other evidence will be false. The rule becomes permissive. A lawyer may refuse to offer evidence that they reasonably believe is false, except for a criminal defendant's testimony on their own behalf. C. Taking reasonable remedial measures. If a lawyer has offered evidence and later discovers that it's false, they must take the following reasonable remedial measures. Step 1. Urge the client to cooperate in withdrawing or correcting it. Step 2. If unsuccessful, seek to withdraw if necessary, and/or take other measures to strike the evidence. Often, withdrawal won't work because the next attorney would have to deal with the same problem. Step 3. If all else fails, disclose the situation to the judge, even if that means disclosing information that would be protected by the duty of confidentiality. Professional responsibility, California. Notes. 60. California difference. The California rule provides that reasonable remedial measures must not involve revealing information that is protected under the duty of confidentiality. Put another way, the ABA rule provides that the duty of candor to the tribunal supersedes the duty of confidentiality, and the California rule takes the opposite view. 7.1.3 False evidence. Perjury by criminal defendant client. The situation is trickier in criminal cases because the defendant has a Fifth Amendment constitutional right to testify and a Sixth Amendment right to the effective assistance of counsel. As discussed above, if the lawyer only reasonably believes that the criminal defendant's testimony is false, then they have to let the defendant testify. But if the lawyer knows the testimony will be false, there's a problem. Scenario. Bombing defendant Ted tells you that he intends to testify falsely that he has never owned a typewriter to type manifestos against technology. What should you do? A. Addressing the problem under the ABA approach. If the client is a criminal defendant and the lawyer knows that the client intends to testify falsely, or has already done so, the lawyer must take measures similar to the reasonable remedial measures above. 1. Try to persuade the client not to testify falsely or to recant the false testimony. 2. Consider withdrawal. And 3. If all else fails, reveal the situation to the judge. California difference. The California rule takes a different approach for false testimony by a criminal defendant client. The lawyer may offer the defendant's testimony in a narrative form if the lawyer, 1. has made reasonable efforts to dissuade the client from testifying falsely and, 2. has unsuccessfully sought permission to withdraw. Professional responsibility, California. Notes. 61. Offering testimony in a narrative form means that the defense lawyer questions the defendant in the ordinary way up to the point of the false testimony. At that point, the defense lawyer asks a question that calls for a narrative answer, such as what else happened? The defendant then tells their story. The defense lawyer is not permitted to rely on the false parts of the story when arguing the case to the trier of fact. 7.1.4 Duration of candor obligations. These duties of candor, correcting false statements, rectifying false evidence, continue until the end of the proceedings, when a final judgment has been affirmed on appeal or the time for appeal has expired. 7.2 Frivolous Claims and Defenses. A lawyer who is serving as an advocate in a legal proceeding must not take a position unless there is a basis in law and fact for doing so that is not frivolous. Keep in mind that a position is not frivolous if the lawyer can make a good faith argument for an extension, modification, or reversal of existing law. Furthermore, despite the general rule against frivolous actions, the lawyer for the defendant in a criminal case, or in any proceeding that could result in incarceration or confinement, may conduct the defense so that the prosecutor must prove every necessary element of the case. California difference. The California rules also prohibit a lawyer from bringing or continuing an action, conducting a defense, asserting a position in litigation, or taking an appeal, without probable cause and for the purpose of harassing or maliciously injuring any person. We discussed this previously with respect to the grounds for mandatory withdrawal. 7.3 Expediting litigation. A lawyer must make reasonable efforts to expedite litigation consistent with the interests of the client. Professional responsibility, California. Notes. 62. California
Oh my god. Where are we? Failing to report stuff? On page... Yes, we're done. Congratulations, you got through 92 pages of reading.